Court is now in session. Please be seated.
Good morning, again. Our next case is Commonwealth versus Melissa Martin, docket number 24P392. Mr. King?
Thank you. Good morning. Congratulations, Chief Justice
Thank
Blake.
you.
Good morning, Your Honors. So my client in this matter has a substance use disorder.
Hold on a minute. We need to get the record on. There we go. Go right ahead.
My client in this case has a substance use disorder. That fact was obvious throughout the entire district court hearing in this matter, and I did try the case in the district court. There are three legal matters that come forward to me that I believe were incorrectly handled in the district court case. The first was the allowance of a state trooper who was not qualified as an expert to testify as an expert to the ultimate issue as to whether my client was under the influence of an illegal scheduled drug. The Commonwealth informed me that day as I walked into the courtroom that they were going to try to qualify this trooper as an expert witness based on his experience, both as a trooper and his previous experience as a paramedic. First of all, it's a discovery violation. No one made the notion ahead of time.
Did you ask for any delay or any postponement on that basis?
I'd like to address that because that's in the Commonwealth's brief that I should have asked for, that I had that right to ask for the delay. But, excuse me, Your Honor, but in the brief, it says, in the Commonwealth's brief, it says my client wasn't in custody. That's not exactly true, Your Honor. My client essentially was in custody. She had been revoked a few months previous. She had been released to a program, but still in custody. So my client was in custody. So it would have been extremely disadvantageous to my client to ask for that delay at that.
Well, if your point is that this was the ultimate issue, which was really, what you're really saying is that it was an impermissible opinion, correct? Not really the ultimate issue, because that would be operating
Yeah, so it's
under the influence.
impermissible opinion about the state of her sobriety.
Right, but understanding that even assuming that your client was in custody, if that was as critical as you're arguing that it was, a short continuance might not have been a trade-off?
Yes, Your Honor, that's a judgment call, I guess, but in the district court, there's very rarely anything called a short continuance. It's usually at least weeks, if not months, and it's just a judgment call, but it doesn't make it any less fair. That's my point. And even the qualification of the expert witness was not done properly. In Guide to Evidence Section 702, there are 5 standards as to what qualifies a witness as an expert. That wasn't done. The judge took it upon himself to suggest that the witness's expertise was an experiential type of witness expertise. And it was never established in any way what that experience was other than the broad statement that he was formerly a paramedic, many years ago, and had been a state trooper for a number of years. And I objected both at the beginning, before the trial began, as to the allowance of such an expert witness qualification, and when the testimony came up, and when he exercised his opinion that, and told the jury his opinion that she was not sober.
Did you ask for a voir dire?
I did not.
So it's just the opinion, the lack thereof, that you're challenging, correct? You're not saying he couldn't have testified to his observations as an EMT?
Absolutely not. He could have testified to his observations, and there was a lot of testimony to observations. Both troopers, 3 troopers testified to their observations.
Oh, his observations of what he observed during his time working as an EMT. Is that proper in your view? It's just the opinion that was improper?
I hadn't really considered that aspect of it. I suppose it's part of his experience, so yes, he could testify to that if it's relevant, and I guess it could be relevant, but I think that could have been relevant to his ability to testify to his overall observations and, what's his experience doing that. As we know, that's the standard in OUI drugs. But for him to make the ultimate decision that she was not, her sobriety or lack thereof, that's where I think the expert opinion went awry. And the ADA that day, and the Commonwealth in their brief, argues that that's allowed in the Gerhardt, and that's false. Gerhardt says it's not allowed, and they cannot testify to that without being qualified as an expert, and he did not get properly qualified as an expert. And I would argue he's not a proper expert. When you look at these 5 standards, his scientific background, he was a paramedic. I know paramedics are not necessarily immediately able to judge whether someone's under the influence of whatever it may happen to be under the influence of.
The officer in Gerhardt didn't testify to any experience about. The officer in Gerhardt did not testify about any experience he had in his work observing people who were under the influence of marijuana, right? He was just offering a straight lay opinion. When you have someone who's been an EMT for many, many years and has observed people under the influence of heroin, why can't he testify to that experience?
Because it was never established why an EMT would have that level of experience to determine whether someone's under the influence of a scheduled drug and whether they're sober or not sober.
Aren't they responding, unfortunately, these days daily to overdoses and Narcan? I mean, that's unfortunately become their bread and butter of their job.
Yes, Your Honor. And in this instance, I think that is actually what contradicts some of the findings in this case overall, because there was no Narcan in this case. There was no...
I'm using that as an example of why an EMT would, as a matter of course, respond to situations with people that are under the influence of something.
Well, his EMT experience was old also. He had not been an EMT for many years. I mean, I believe it was 8 years. I'm not sure, but it was somewhere in that area. So it wasn't like he had been an EMT yesterday, and he suggested that he did not keep his certification as an EMT. Or at least, he did not keep his certification as a paramedic. I'm not sure his certification as a basic EMT came up, whether he has it or not. But he did not keep his certification as a paramedic. The other issue in this case that I think the Commonwealth failed and the judge did not require is the issue that there must be a clear what the drug is. And this is where my clients, and I thought during the induction ceremony earlier today, it was very interesting to hear the idea of the Lady Justice and the blindfold, because I don't think the police were had their blindfold on and trying to do justice that day, because they saw, there's no question, and it's put in the response brief twice, a list of things. Some of them are not correct, but are accurate or in testimony, but there's no question there was drug paraphernalia in that car, and there's no question she has a problem with drugs, and she has a lifelong affliction with that. There's no question about that. She had an interlock device on her wheel. The state troopers immediately knew that she had a substance use disorder. There was no question they knew that. It was evident as soon as they pulled up. That evidence overwhelmed the case at that point. Everybody assumed that, oh, it must be drugs. But if you look at the facts, they're really not there.
Would
They're
you
really
say,
not
though,
there.
why could the jury not infer exactly what they apparently did from the existence? I understand that they don't have to on this evidence.
Yeah, right.
But the fact that you have a fresh track mark, you have a statement in the medical records to a same-day use and potential overdose, although I understand there's also competing evidence that suggests no intoxication at the time, evidence of intoxication in the reviewer's mind. There's the capped, loaded, unloaded needles in the handbag. There's a cap from a needle in the cup holder of the car, and then there's the bag of dope that nobody identifies as anything other than dope. Why is that not enough to infer that that's
Well, the Commonwealth, both in their brief and essentially in court, made that argument, and I call it the magic 8 that they have here. She admitted to heroin use early in the day, yes, but heroin isn't something that earlier in the day use is going to affect you to be driving 8 hours later.
Okay, but they have the observations then also of what your client looked like at the time that she's at the side of the road asleep with the door open.
Excuse me, I'm sorry.
No, that's fine.
There's two different observations about that simultaneously in evidence. You have the testimony of the state police troopers who said she was lethargic. They didn't say much beyond lethargic. They said lethargic. But you have a paramedic who's simultaneously on the scene in the medical evidence that's in this record that says she was orientated and alert. So there's differences between that.
And that's up to the jury to resolve, right? Because you have at transcript 50 that she was unresponsive, that the trooper tried to knock on the car and got no response. He grabbed her arm and shook her in an attempt to wake her up. Her body arched and her head rolled back. That's up to the jury to decide which to believe.
But that was a Mass DOT driver who woke her up, actually. And
Why does that matter?
I mean, that makes him pretty credible, right? He has no reason to.
But I think that I disagree with that, actually, because somehow it got in the record that there was a sternum rub done, and that is in the list of 8 things. But there was never a sternum rub done. That's nowhere in the evidence. He shook her.
Isn't that in the medical records that came in as Exhibit 1?
It is in the medical records, but that is, I don't know where that came from in the medical records. It didn't come, obviously, from my client, and it clearly didn't come from anybody at the scene, because they said they shook her. That was testimony.
Move to redact that portion of the record?
I did not, Your Honor. So he shook her. It's a lot different than the sternum rub. You know, they said she struggled to get out of the car. It depends who you believe, and that different troopers testified differently. Says she was confused and disorientated. Again, that depends who you believe. The paramedic says she was alert and orientated. The track marks you mentioned, they weren't bleeding track marks. Fresh track marks, I don't know what those mean. But even in the morning, he said it was dried blood, so that shows at least a period of hours, I would say. But the issue I'm trying to address, actually, and I'm sorry I got myself off track slightly, is that the Commonwealth never established what the drug was. There's never any evidence of testimony establishing what the drug was. They didn't even establish the drug. The dope in her pocket was heroin. Now, you can look at either the Funk and Wagless Dictionary, Merriam-Webster Dictionary, or the Urban Dictionary. Any place you want to go, dope is a lot of different things. It's not just heroin.
But the medical records say she admitted to using heroin.
In the morning. They said she admitted
Okay, that's a different issue. I mean, I thought you were saying that there was never any identification of the substance that she used as heroin, but the medical records do identify it. There's a separate question that I perceive you raising two arguments, which is whether they identified the substance and whether she was still impaired on that substance when she was driving. But the medical records, it seems to me, does identify the substance as heroin.
In the medical records, she said she had not used any heroin. She said she had not used any opiates that entire night. She said she only admitted in the morning to using it. But the burden of the Commonwealth is to prove that the drug she was under was a scheduled drug, which was taken by judicial notice, no objection to that. Heroin is. But they never proved that heroin was the drug, if there was any drug, influencing her at that particular time. There was never any evidence entered into the record that that was evidence. After they did the judicial notice, the ADA said, we still know we have to prove the drug. They never did it. It never happened.
So if she admits to using heroin at some point that day,
yes,
and then the help van driver finds her in the condition that she was, why can't the jury infer that, in fact, she had used heroin closer in time to when she was driving?
Well, I guess they can, but I don't think the record supports it. I don't think the evidence supports it. Heroin was, they have to show that it was heroin, and they never showed that. So even if the jury infers that, how did the Commonwealth prove that it was heroin that was impacting her at the time? It could have been sleep. She said she was asleep. That's, people, you know, I'm not saying it's a normal place to be sleeping, but if you were sleeping in that situation and someone unexpectedly woke you up, I suspect you would feel disoriented for a short period of time too. And the third issue is operation, that I don't think was completely proven. We know from the interlock device that that car was there for an hour. Now, granted, the car likely got driven there by her, okay? I mean, it didn't just materialize there. So it likely got driven there by her, but that was never proven. So even if we buy that she did ingest heroin, she said she broke down, went to get gas, and that was proven by the, not proven, but indicated by the fact there was a gas can in the car. If she went there and got the gas and couldn't get the car started, and she was dependent upon drugs, what's to say that's when she might have taken the drug, if in fact she ever took a drug? I don't believe she did, but I'm just saying hypothetically, if she took a drug, wouldn't it make more sense if she actually would have taken it after the car broke down and she was there, as opposed to driving with the drugs? And there was no, but that's contradicted by the fact there is no used needle anywhere in the evidence. There's no used needle anywhere. So there's no real evidence that she took a drug within that short period of time. The admission in the morning would not, there was no evidence and there's no likelihood that the admission in the morning would have left her under the influence that late in the day. So I think the Commonwealth never really married the two required elements of operation and under the influence at the same time. It's very possible that car could have been driven there, broke down, passed, and even if she was drug dependent, she took the drug then and was under the influence when they came there. Or it's just as possible, it may seem unusual, but it's certainly, the Commonwealth's burden is beyond a reasonable doubt, as we know. So not what might likely happen, or probably or possibly happen. It's beyond a reasonable doubt. It's possible she's upset, she's in a bad mental state, she drives down the ramp, the car breaks down, she goes get the gas, it doesn't work, it's still broken down. Maybe she was exhausted and fell asleep. It is a plausible explanation. And the explanation of waking up when somebody's asleep is plausible too. Is it the most likely one? Probably not, but it's plausible. But if you contrast that to the fact that there is no proof of the drug in her system at that time, in fact, there doesn't appear to be any drug in her system based on the medical records, and you can't marry the two things together, operation and under the influence. So I think the combination of the three things, she was disadvantaged at this trial. that she had an expert who was not an expert testify to her sobriety. There was no marrying of the operation together, and there was never really proven, not really, there was never proven what the scheduled drug that she supposedly was under the influence of at that particular time. So I think that's the reason I brought this case here, and I very much appreciate the attention of the panel. Thank you very much.
Thank you. Attorney Jansen.
Good morning, and congratulations, Chief Justice Blake. May it please the Court, Catherine Jansen on behalf of the Commonwealth. First, just to start with the sufficiency, we have to look at this case in the light most favorable to the Commonwealth, and so when we're looking at these facts in the light most favorable to the Commonwealth, just because there could be alternate explanations does not mean the jury was so required to find that. And I think here, based on the totality of the evidence, including the van driver coming and finding her at the bottom of a dangerous on-ramp, passed out and arching her back when he tries to wake her up. Although he had to use a sternum rub to wake her up, that's in the medical records at RA 43, 48, 57, 61, 65, and 67. And I would note in his testimony, he just said he tried to shake her and she was unresponsive. He didn't say one way or another whether he didn't do a sternum rub. So I would say the medical records aren't inconsistent with his testimony on that fact. And also her appearance and demeanor when the troopers responded, that she was lethargic, out of it, and while one of the troopers, Trooper Celia, I believe her name was, said that she was awake and alert, quote unquote, in that sense, she was still lethargic and kind of out of it. As well as her admission to shooting heroin earlier that day, I think the jury could reasonably infer that after obvious police involvement, she could be minimizing about how close in time it was, and that coupled with the cap in the cup holder, suggesting she shot up in the car at some point, and the fresh track mark where the trooper said on cross-examination, I view the fact that there's still dry blood on her would indicate it's fresh. And also access to heroin and dope, while nobody explained what dope was, and the trooper didn't quite get out all the way that it was consistent with heroin. I think there was a link to that, especially in the medical records on page RA 49, where she admitted to possessing that heroin in the car.
A side issue on that point, the defendant was not charged with possession of heroin, is that correct?
She was, but we null-prossed that case because the chemist wasn't available, or the drug testing hadn't come back for that bag.
Okay, as part of the same complaint?
It was, this case was a little bit weird from my understanding. There was an earlier complaint from when the incident first happened, and then there was a second complaint that issued in 2023, and they were combined somehow, and
I don't need you to waste your time.
Sorry,
on that. Thank you.
so
I
it
appreciate
was
the
part of the
answer.
same incident, though, but it was ultimately null-pros because the chemist wasn't available on that.
So you need the medical records, right, to establish that the substance was heroin? Because the trooper, I think what was going to happen was when he testified about the tan powder, there was going to be testimony elicited that that's consistent with heroin, but he never got that.
Correct, he never got there. There was an objection, and I think the prosecutor, and I believe it was overruled based on my reading up the record, it's a little indiscernible, but I think the prosecutor accidentally moved on without completing the thought.
So you need the medical records.
Yes, Your Honor, yes, I'm sorry, to answer that directly, yes. The medical records I do think are important in this case. And just briefly address it, if the court has no further questions about the impairment issue by heroin, I would just briefly address the expert testimony by Trooper Vath. I would say that, well, one, just to address the late disclosure, there was no bad faith on the part of the prosecutor. I think it was very clear from the record that, this is district court. We talked to our witnesses day of, for better or for worse sometimes, but that's the reality of the busy district court. And she, upon immediately learning of this prior history, she immediately told the defense attorney, and based on that, and there was no indication that the defense attorney did not have this trooper's name or information before trial to talk to him himself if he wanted to about anything.
No indication that there was going to be any testimony elicited about his past history as an EMT or paramedic?
No, correct, Your Honor, not until the prosecutor told him, but that's to say he's not a surprised witness just on that topic. That being said, the judge was within his discretion, I think, it's a little confusing about if it was implicit or explicitly qualified as an expert. The judge made a comment that it's based on experience, which is a proper basis to qualify an expert. I would point the court to Commonwealth v. Booley, which is cited in my brief, that an EMT who has testified about interacting with people who are under who under the influence of some type of narcotic and their experience dealing with those people can be sufficient to qualify them as an expert. And here, I believe the foundation was laid from transcript page 57 through 59 and 65. He testified that he was an EMT basic from 2002 to 2006, an EMT paramedic until 2016, until he became a trooper, and during which he would deal with someone under the influence of substances almost, quote, daily, and continue to do so as a trooper, although not quite as frequently.
I mean, the foundation was pretty minimal. Wouldn't you agree? I mean, he doesn't say heroin, he just says, I interacted daily with substance users.
Correct. And I mean, it would have been helpful for it to be more robust, but I think part of that was the judge limited kind of what he could talk about in terms of linking it to, he said he could offer an opinion about impairment or sobriety of what this person appeared to be, but couldn't link it to a specific drug. And that was, one moment, Your Honor, just so I can have the page number for you. That was at transcript page 8. The court said, okay, all right, but you can't make a correlation to any particular like opiate or Class D or Class E or anything like that. So I think that might explain the foundation.
Right, but now you have a problem where, I mean, any individual substance might affect a person differently. And so now you have no connection between what he observed in the past versus what he observed with respect to this person.
I think the difference is, I don't think you necessarily need to have for him to make an opinion or testify about an opinion about impairment. I think he can testify about somebody who's impaired under some substance abuse generally versus what type of substance it is. I think that just goes to the weight of the evidence, not its admissibility.
Well, let's say she was charged with OUI marijuana and the same testimony came in. Would that be proper under Gerhardt?
I think under Gerhardt, if somebody testifies regarding their experience of dealing with somebody under the influence of some substance, I don't know if it necessarily under Gerhardt, it's so narrow that it has to be their experience of interacting with somebody with marijuana. I don't want to misrepresent the holding of Gerhardt.
Well, Gerhardt says that there's no consensus about what someone under the influence of marijuana, what their symptoms are. So if this was an OUI marijuana case and you had the same testimony come in that he opines that she was under the influence of marijuana, it's hard to see how that can be reconciled with Gerhardt. And I don't know why it's any different because it's a different substance.
Understood, Your Honor. And if that's the case, I would switch to a prejudice argument. And here I would just suggest that in this case, there was no prejudice due to what I would characterize as very strong, if not overwhelming, evidence of impairment by heroin. And the fact that it was very minimal testimony, it was lack thereof with the testimony about sobriety or lack thereof sobriety and impairment. And this person was not qualified as an expert in front of a jury. There was no expert witness instruction given, which I do think is helpful in this case, is to prejudice because it doesn't highlight any expertise to have the jury give undue weight to that. And I would just point to Commonwealth v. Gallagher, 91 Mass App Court at 389, where in view of the entire case, this testimony wouldn't have made a difference, I think, to the jury in the outcome. I'm happy to answer any other questions the court may have.
I don't see any additional questions. We'll take the rest of it on your brief. Counsel, thank you both. Very well argued. It is under advisement.
Thank you.
We're going to call the last criminal case in the courtroom, and then we'll take a brief morning recess. So our next case is Commonwealth versus Jose Annabel Rodriguez, docket number 23P 1262. Good morning.
Good morning, Justice Blake. Congratulations.
Thank you.
Privileged to be here to see this today. May it please the court. My name is Adam Oos. I represent Jose Annabel Rodriguez. Mr. Rodriguez asks this court to reverse his convictions where the admission into evidence of several uncharged acts was error because the evidence was more prejudicial than probative.
Can I ask one question before you get too far into your argument? am I understanding correctly that the way that these crimes were indicted was as a continuing course, essentially with respect to both the indecent A and Bs and the rapes? They were over diverse dates, and reading the transcript, it appears to me, and I'm just looking for some direction if I'm misunderstanding this, that there's no specific unanimity argument, it seems to be that it's repeated contact, repeated vaginal rapes, repeated hand on vagina, repeated conducts. Am I right about that?
As I stand here, I blank on whether the words diverse dates were in the indictment. I'm sorry, but it was certainly...
That I can tell you they are.
Yeah, okay, so it was certainly a time period between, I think, January 12 and January 2016. And it was indicted as sort of an ongoing thing. And I talk in the brief about one of the concerns about the lack of unanimity because there were different incidents applied here.
But here's my question, and maybe if that's the case, is it true that the argument that you're making about the uncharged conduct covers various incidents that fall within these indictments? I mean, I know that your argument would not be that, but it looks to me like you're saying that there are all these pieces of testimony about, for example, the vaginal penile rapes that are uncharged acts, but if the indictment is for multiple incidents of this particular, or this conduct as an ongoing issue, then those are not really uncharged acts, are they?
I think the answer to your question is no. Let me try to answer it this way.
Okay.
Tell me if this gives you the answer. So we have 4 indictments of specific acts. We have rape, vaginal, rape, anal, and 2 counts of indecent assault and battery on a child. One was hand on breast, and the other was vagina with hands. Mm-hmm. The motion in limine that the Commonwealth filed prior to trial had 4 specific acts that were other than those,
right.
Differently described acts. And then during the course of trial, additional acts came in that were not within those indictments, that were not described in those indictments. For example, that the defendant, and they spent a lot of time on this one, the defendant placed his penis inside the complainant's underwear.
Okay.
That he licked the inside of her vagina, and that he, so these are, as I read the record, these are acts that are not articulated in the indictments and are not articulated in the motion in limine. The point, though, that I'm trying to make, I guess, with both the motion in limine and these additional acts that come in is that they are separate and apart from the indictments. And they don't have evidentiary value here, that they're not...
Why are they separate from the indictment? I understand if it's one of the 4 categories that are exclusive of the 4 types of conduct categorized within the indictments. Then I understand that distinction. But if you're talking about penis inside the underwear, but inferentially against the body, and understanding what the definition of penetration is when it comes to vaginal rape or non-anal rape in this particular case, why is that outside the indictment is my question. Am I missing something?
Well, I mean, I think at the point where... because that wasn't described as an act of penetration. I think the complainant testified that he took his penis out of his pajama fly, placed it inside of her underwear, right. Between her underwear and her vagina, and I don't have any recollection of it in the record of her even indicating that there was even slight penetration into the vagina. So
But I read your brief to also be arguing that the 2018 incident was uncharged conduct when he was alleged to have put his penis in her vagina when they were on the couch. That is charged conduct, is it not? I mean, the way that the jury was instructed was on the vaginal rapes, it was a course of conduct between 2012 and 2018. The anal rape, the jury was charged it was the one incident in 2012. That was the only evidence of the anal rape. But it seems to me the other incidents where the 2018 incident and the incident on the chair is charged conduct.
I think there's the incident on the purple couch. I think what she said, she was watching a cowboy movie. And admittedly, the Commonwealth argued during their closing argument that there was an indictment for each of the alleged rapes. The way I argued in my brief is with some I asked this court to take some degree of caution when looking at these different acts. Was this indicted? Was this not? Was it additional? Was it a contemporary bad act? And with the, generally speaking, case law tells us that where there's this ongoing course of conduct that's alleged here, there doesn't need to be this specific unanimity that the complaint doesn't need to say it happened, this particular indictment was this particular incident. The thing I take exception with this case is that we have her describing two very specific incidents of penetration. And in those instances, we must be cautious that the jury is not, that the jury is unanimous as to which particular incident, and I think this is from Kirkpatrick, which particular incident is the indicted offense. So what I think I was trying to argue in my brief is that if one of these is the described incident or suffices to be the indicted offense, we have to make sure that the jury is unanimous as to which indictment or which act is the act that they are convicting upon. Part of that is the idea that one of these acts is an additional bad act. If it's not the indicted act, if it's not the one that the jury is convicting on, then the other one is a alternate bad act that was not named in the motion in limine. So, but the overall arching idea here that I'm trying to get at is that we look at each of these acts for their probative value. They don't have, the additional acts don't have evidentiary value. They don't establish a pattern, ID, lack of accident, alibi. These were not at issue here. And they do nothing to help the jury understand the nature of this relationship. We have other evidence of that. In either case.
Well, but let me ask you about that, because the defense at trial, in part, was recent contrivance, right? And so doesn't the uncharged conduct go to explain the victim's actions in this case, particularly where she was, I think, age 5 when the rapes were alleged to have begun?
If you're referring to her prior denials, they do not, because there's other explanations for her actions. These additional acts are not necessary to explain that. In fact, her reasons for denial were independent of the bad acts. She specifically said, in 2012, when the family came home from the funeral, I didn't want to upset my mom even more. I'm sorry, when the family came home from the funeral in 2012, what the complainant said is, I didn't tell because I didn't want to upset my mom. And I view that as an independent reason. Later on, when the disclosure about the alleged incident came out to the grandmother, she was again asked, what did you tell your mom? Why didn't you tell her about other things? Because I didn't want her to think that I had lied, or that I didn't want her to be mad at me for not telling her previously. So my view of the evidence is that those bad acts don't explain her motivations, as opposed to a case like Child's, where the prior acts gave some context to why the complainant in that case didn't react to the defendant's advances in that case, because there had been prior acts that came in to explain that this was ongoing conduct.
But why doesn't the normalization of that ongoing conduct go to explain why there wasn't an earlier report or why there wasn't a more comprehensive initial report? When, I'm paraphrasing, but there is one point at which the victim says, well, this just was my life. This happened all the time. So why doesn't that go to provide some justification for why the disclosures were made as they were?
I'm going to try to answer it this way. I think that goes to the prejudice of this, of the prejudice from the admission of these acts. She explained in summary faction at some point that this was my life. This is ongoing conduct. This was happening weekly. This was just my life. That much case law says is allowed. The problem with these acts is that they outnumber the charged conduct, and the level of detail is gratuitous, it does nothing to help the jury understand those actions. The jury doesn't need to hear each enumerated act in order to understand that this was what she says her life at the time. We have 11 pages with references to the uncharged conduct. We have 7 pages with references to the charged acts.
Just to clarify, so when you are counting pages, you're including incidents like the incident on the chair and the incident on the couch, correct?
Yeah.
All right.
Yeah.
If we consider that to be charged conduct, it seems that the evidence of the uncharged conduct was relatively minimal compared to the testimony about the charged conduct. I mean, that's the problem I'm having, right? Your argument is focused on conduct that it appears to me that the bad acts motion accurately identified what the uncharged conduct is. And that's the way it was also argued in closing.
2 points on that. Yes, the bad act motion, the motion in limine, enumerated which acts the Commonwealth was going to bring in. Those were specifically enumerated. We take exception to the fact that some of those acts that came in were not in that motion in limine, and more importantly, when the judge gave a limiting instruction, the penis in the underwear incident was not in that limiting instruction. The limiting instruction didn't include it, which allowed that to come in
because that was charged conduct, right?
No, I disagree that it was. The penis in the underwear, there was nothing about that first of all, it wasn't charged as, again, she didn't testify about that being an act of penetration. It wasn't one of the motion in limine bad acts, and it wasn't one of the descriptions in the indicted act. So I maintain that is not part of the charged conduct. I maintain that that is a separate bad act that was not named in the motion in limine. While we're on the topic of penetration.
Before we get there, could I just
Yeah.
ask you about the decision to decline a contemporaneous limiting instruction?
Glad you asked, because counsel said she didn't want to highlight the bad act evidence. The judge offered it. She said she didn't want it. And I think her reason
You're
for
not
doing
claiming that was ineffective, right? At least in this brief.
Not in this brief, no, I haven't argued that. But I will say that when that option was removed as an option, it was incumbent on the judge to then exercise a different option, another available option, and that would have been to strike some of the most offending testimony. With the minute or so I have left, we also argued that the evidence of penetration, there was no evidence of penetration to support the conviction on count 2, charging unnatural sexual intercourse, particularly where the complainant indicated that the defendant touched the hole, but there was no direct evidence that of any kind of penetration into the anal cavity. There was no inference of penetration. She didn't testify that she could feel what she felt. She said she couldn't feel what his body was doing.
She did testify that he put his penis in my butt. Would the jury not infer from that or understand that to mean?
No, it cannot, and here's why.
It had to be more technical. She had to use a different term.
Had to be. The case law says we must use the technical definition of anus, that being that last part of the rectum. And in my brief, I mentioned the Redgate case, which talks about the approved instruction of it must pass through that plane if you put an invisible plane over the rectum. That adherence, Nylander Court talks about that adherence to that technical term to make sure that somebody is not convicted of an unsupported crime. There must, in order to draw any kind of inference that there was actual technical penetration, there has to be something more than just a description of anal penetration, because as the Nylander Court says, it's very common that the colloquial use of anus is used, and that would not be right. We want the technical use.
I see that your time's running out, but in addition to, as Justice Hand has described, didn't she also say she could feel his penis in her butt and it, quote, touched the hole?
What part of
In
What
the light
part?
most favorable to the Commonwealth.
Because again, there's no evidence that there was any kind of touching the hole is, I would argue, is not sufficient. There has to be some kind of evidence of actual insertion. And I'm sorry, I blank on the case name, but there was particular, one of my cases I cite where the complainant talked about feeling the defendant's tongue go inside and feeling something wet. I think that's distinguished here. That's not what we have.
Let me just make sure there's no further questions. Thank you. We're going to have to leave it there.
Thank you, Your Honors.
Attorney Knight.
Good morning, Your Honors. Erin Knight on behalf of the Commonwealth. With me today is the trial attorney, ADA Laura Montgomery, and we're asking this court to affirm the defendant's convictions. Let me also congratulate the chief on this historic morning. I will start off with the bad acts, as my brother would describe them. I think Justice Han and Justice Shin, you are exactly correct that a number of the instances of testimony that he describes as bad acts are in fact charged conduct, where this was presented as a range of dates over diverse dates, a continuing pattern of this conduct. I can actually, if I may, help the court out a bit in going through transcripts. This is, I believe, the May 2nd transcript. 134 and 138 talk about the penis between the underwear and the vagina. That would go to count 1, as intrusion into the vagina is not necessary. Touching of the vulva or labia is enough, and that's under Nylander. On page 151, you have licked nipples, flipped nipples, kiss on the lips, and finger in mouth. Flipped nipples goes to count 3. Licked nipples, kiss on lips, and finger in mouth are the enumerated bad acts in the motion in limine. 151, 152, and 166, touch penis to vagina. Again, that's count 1. 156, penis and vagina. That's count 1. 163, penis touch the hole. That's count 2. Vagina with hands. That's 164 and 165. That's count 4. 168, mouth on nipples, mouth on mouth, and mouth on vagina. Those are the enumerated bad acts in the motion in limine. 169, the lick inside of her vagina. 171, hand up pants and touch of leg. Again, those were enumerated instances, as well as argued before the judge during the motions in limine regarding the first complaint testimony. And also 191, hand on vagina, that goes to count 4.
And if we look at the verdict slips that start at R43 through 46, they describe each of the rapes and the indecent A and B in a similar way to what you've described. Had there been, and I apologize, I haven't gone back to the transcript to look, was there a request that the verdict slips specifically identify a date for each offense?
I do not believe so. I can go back and check, but I don't recall that. And I also, where these were indicted as over diverse dates, I highly doubt that the Commonwealth would have agreed to that in any event, because that's not how the evidence was presented or charged. I would also point to the fact that there was a specific unanimity instructions given. So the jury did know that on all counts they had to find unanimously that at least one of these instances sufficed for that charged conduct, indicted conduct. Again, there was no contemporaneous instruction given with the bad acts, but that was denied. The defense counsel did not want one. In any event, one was given during final instructions. So the bad acts that I would say are bad acts that were introduced through the motion in limine are going to the point of this case was a case of delayed disclosure. The defense was it didn't happen, recent contrivance. The continuous course of conduct, as we know, goes towards the fact that this did happen in the victim's credibility. And I think most demonstrative of this case here is a quote from Cal Cagano at page 27 that says, It demonstrated the defendant's long-standing desire for sexual contact with the victim and his long-term pattern of indulging in that desire. And that's exactly what this information was for. And I would also point out, we have a child victim on the stand. The penile and anal penetration, when she started her testimony about that, that started, or the earliest she could recall for trial anyway, was when she was 5 years old. So it's very hard when you're not allowed to lead a child witness in not maybe enumerate or eliciting more information than maybe you would be able to if you could lead or have an adult witness. But I would also point out that this was a pattern of conduct, and this survivor, this victim, had dealt with this for years by someone she believed to be her grandfather. And so I think the information that came out was absolutely relevant and not prejudicial. If there are no further questions on that, I would touch briefly on the anal penetration issue. Penetration or intrusion into the genital or anal opening is required to prove rape. And penetration can be however slight of the anal opening. And here you have that it touched the hole. It is not along those cases where it's just information that he put it in my butt. She did say that, but she said more. I would also take it in context with what was happening during that encounter. He put his penis in her vagina, thrusting back and forth and then flipped her over and continued the act. And here we have her, with the touching of the hole, you have that slight, however slight, penetration. And I would also argue that...
What's your closest case?
The closest case, I would say, so if you look at Gallant and Todd, you also have Nylander and Martino, which is the
reasonable inference, right?
Yes, it's a reasonable inference. And I would also point out that under this line of cases, when it talks about the penetration needing the anal actual information, it doesn't go on to say that you have to say that it went fully inside of the anal opening or anything of that nature. It is a however slight standard. And also, the court should keep in mind that this was a 5-year-old child at the time of this act. And so I would just point the court to those cases and say that this case is certainly more here. You had a 5-year-old child who's recalling this at 17. And so if the court has no further questions.
I have one question. So in your brief, you also cite the detective's testimony.
Yes.
Which perhaps should have been objected to.
Well, so I would say...
So without it, is the evidence still sufficient? It seems to be the clearest evidence of penetration.
I would agree with that also. It was actually the defense that brought that out.
Oh, it was, okay.
It was the defendant's witness. But yes, the detective does state that during her forensic interview, she stated that there was penetration. I will be candid with the court that, I'm not sure if it was his general descriptor or, she used the word, but by any event, she doesn't have to use that word. Her descriptors of how things happened, of what happened, is enough. She does not have to use the word penetration in order to suffice for penetration.
I don't see any additional questions, so we'll
Commonwealth,
take the
the rest of
rest
it's
in your
brief.
brief.
Thank you very much.
Counsel, thank you very much for excellent arguments. The case is under advisement. We are going to take about a 10-minute recess, and when we return, we will hear the DCF matter. Thank you.
All rise. court is now in session. Please be seated.
All right, we are back on the record. We are now going to hear the Department of Children and Families and another versus Mother. This is docket 24P280. I just want to remind counsel that this is an impounded case, so please do not use any names. Attorney Bagnell, when you're ready.
Yes, first of all, congratulations, Chief Justice Blake. It's quite an achievement. It's wonderful on behalf of women. So anyways, start the record. My name is Carrie Bagnall. I represent the mother in this case. And on behalf of Mother, I am requesting that this court reverse the lower court's decision finding Mother unfit and permanently committing her daughter to the custody of the department until 18 years of age. I'd like to point out that at the conclusion of the evidence, the trial judge found that the child was not removed from Mother's care because of Mother's substance abuse or mental health, but rather the child was removed solely because the child engaged in self-harm, self-injury, and indicated that the reasoning for that was the deterioration in the mother and daughter relationship. At the end of the trial, the court concluded that Mother had done considerable work to address her sobriety and mental health issues, but had done little to repair the mother-daughter relationship. The court also acknowledged and found that the department had done little, if nothing, to facilitate the relationship between mother and daughter while child was in the department's care. The court also concluded that the department failed to facilitate parent and child visits during the course of the case, and/or the department failed to facilitate any family therapy between child and mother. Throughout the court's findings, Your Honors, the court puts much emphasis and points out on a number of occasions the child not wanting visits and the child not wanting to come home to Mother, and as evidence of Mother's inability to repair the relationship between mother and child.
So could I ask you about that? Because at page 26 of your brief, you say, here, the trial judge erred by basing his findings of parental unfitness on child's unwillingness to return to the mother's care. There's no record cite for that. And in looking at Judge King's findings as a whole, there's a lot about the fractured relationship, and he talks about the child's preference and talks about the weight he gives it. I don't see him, and I'd love you to show me where he does, connecting the finding of unfitness to the child's unwillingness to return to mother.
I will concede, Your Honor, that at no point does the judge make a particular finding regarding, given the child's preference, sole consideration in the finding of unfitness. In fact, the trial judge at the conclusion indicates that, well, he did give child's preference consideration, that was not the sole basis. However, a careful reading of the record and the judge's findings indicates that the sole purpose or the sole reasoning in finding mother unfit was mother's inability to bridge the gap between mother and daughter, mother's inability at the time of trial to correct the relationship between her daughter and herself.
I think it's broader than that, though, right? We have the findings about physical and verbal abuse. We have findings about the way mom managed or didn't manage the daughter's education. And then we get to sort of the safety issues, and when the child is cutting and expressing suicidal ideation, mom's answer, and this is, I'm paraphrasing, to if the daughter comes back to you, what are you going to do? And her answer is, we're just going to talk it through. That's a little bit bigger than the way you've described it. And I understand why you're describing it that way. And I'm also mindful her rights weren't terminated here. And that puts us in a little bit of a different standing or footing in this case, I think.
It does in the sense that mother has recourse down the road following this trial. However, I'd argue that a finding of unfitness still, in the context of a care and protection case, is deserving of review when there is an issue that the parent feels is strong enough to bring it to the appeals court.
No one's challenging your ability to be here on this case. I guess I'm trying to figure out, based on the trial evidence, it seems that mom was not, at least at the time of trial, presently fit to take custody of the child. That could change. It happens in many cases, fortunately, and it may happen here. We don't know.
But the reasoning the court used, the sole reasoning, because the court does acknowledge that child's not taken from mother's care because of her mental health background, because of her substance abuse issues. The court finds that the sole reason the child's taken from mother's care is the total deterioration in the relationship between mother and child. The court does, in its conclusions, point to the child's statements regarding being called names by mother and mother's partner, the punishment of being sent down to the basement, which was heated, had three accesses to leave. The court uses those examples, but there are 51As and investigations going on before March 11th, 2021. And that is revealed during that time. Child's not taken from mother. Child's taken from mother after mother and her partner bring the child to the hospital, concerned about child's emotional well-being, mental health status, and the potential at that point that child's cutting herself. And they do the right thing. They bring the child to the hospital, and the following day or 2 days later, child does not want to go home with mother. And the care and protection is initiated at that point. I would argue, based on those facts, the care and protection is initiated on child's desire not to go home. That obviously isn't the issue here in this case. The issue I raise on behalf of mother is when the court willingly states that the sole reason that mother is unfit is because she has not addressed the circumstances without really articulating what those circumstances are. I'd say the record's kind of devoid, other than the 2 instances in the past. I'm suggesting that cumulatively, the findings of fact actually do take the child's preference, if not solely, but really outweighs the facts towards unfitness, which I would argue, and I do argue in the brief, that there's not enough facts here to prove mother's current unfitness. The basement issue, the calling of names issue, at that point in 2023, that's stale evidence. There was nothing really leading up to the trial, to 2021, the removal of the child to the trial, to point to any of those issues continuing. Rather, the court really puts emphasis on the fact that there's a lack of visitation between mother and child, and there's no family therapy. But then the facts, the testimony, especially of the social worker, bears out that is solely due to child's preference and child's desire. Child doesn't want to visit mother. Child doesn't have to visit mother, according to the social worker.
Can I ask you a practical question? The child's now 16. As a practical matter, what happens? Judge sends her home, and what? And by the way, home to Western Mass, where she's never lived, where she's never been in school, has no ties. Mom chose to move out that way.
Mother did choose to move out there because she had a spot in a program that really assisted her in her sobriety.
When she graduated from that program, she chose to stay, right?
Yes, she did. But again, Yes, she did choose to stay there. And she did have some difficulty in making travel arrangements to visit her daughter. However, this judge found that the department did nothing to enable that visitation. And in fact, in the judge's order, she makes 4 findings or 4 orders. She finds the mother unfit, orders the child into the permanent custody of the department. But the other 3 orders, final orders of the judge, have to do with the department, more importantly, the department's lack of attention regarding family therapy and visitation. And I would say, again, the department's sole reliance upon the child's preference.
With the goal to reunify the child with mother.
With the goal to reunify child with mother. But the judge did rule that the department should, if necessary, provide funding for mother to reach child or child to reach mother, and that the department should immediately set up some sort of family therapy.
So what is your best case for a case that the rights haven't been terminated, but the constellation of facts are at least similar to this case that says that this is a reverse? What's your best reported case?
Of a care and protection or best reported, the best case, the similar case to this case is, which I included in the appendix of my brief, is guardianship of Rhea. That being a guardianship is very similar to a care and protection. It's not a permanent, it's not termination of the parental rights. And I would suggest that that case is directly on point with the facts here. Scant evidence of mother's unfitness, but because the child, who is 14, I believe, in Rhea, not much difference than this child's age. In fact, I think older by a year. Error for the judge to rely solely on the preference of the child. And there were alternative arguments made that the unfitness in that case, the evidence supported the unfitness, but this panel didn't find that so. In that instant, Rhea had observed domestic violence incident, and there was periods of time, I believe, due to vacation, that mother missed visits. But this court found just last year that that was not sufficient for for upholding the finding, the trial judge's finding of unfitness. So I would ask you to review guardianship of Rhea. I do believe the facts fit squarely within that case. And to conclude, that taken together, the facts, the exorbitant weight put on the child's preferences all through this case by the department and ultimately by the trial judge in reaching his decision don't amount to unfitness, clear demonstration, clear and convincing demonstration of mother's unfitness. And I'd ask for a reversal on behalf of mother.
Thank you. You're splitting your time 10 and 5, is that right?
Yes, sir.
All right, Attorney Bayless, you're going to go first? Great.
Madam Chief Justice, and may it please the Court, Jeremy Bayless for the Department of Children and Families. I think a good place to start is with why mother was unfit at the time of trial, because it's not just because she didn't fix her relationship with the child. She's the one that damaged the child, leading to a poor relationship. And that instability and chaos that did harm the child started well before the removal. From birth, mother has kept the child in a chaotic environment. She was briefly raised by mother, then she lived with her father, then she went to live with the maternal grandmother. They moved from location to location. Mother was incarcerated for a large portion of the child's childhood, for 18 months during that period. When child began living with mother and her partner, she was exposed to the violent interactions that mother and her partner had with outside people. She was in the car for a fight that led to arrests with the incident of the traffic accident or insurance conflict that led to a physical altercation. after she had the worst possible year imaginable, in which her stepfather, grandmother, who had been a primary caretaker, and another family member all died in the same year, she began to act out a little bit, and the parents' response to that was to physically strike her, to berate her, to not allow her into the home, and then also importantly, as noted by the judge, to not allow her to access her education. In response to some concerning behaviors online, mother just refused to let the child have access to a computer or the internet at a time when school was fully remote at least one day a week. So it wasn't just the case that communication was difficult between mother and child. The flawed relationship was a result of mother's actions and the result of physical and emotional abuse that happened. Physical and emotional abuse that mother gave no indication at the time of trial that she had learned anything as to how to prevent from recurring. The triggers for mother and her partner's abuse of the child, the perceived stealing and bad behavior, as Your Honor noted, mother's response to that, mother's plan was that they were just going to encourage her not to do that. Which did not indicate that she had developed the parenting skills to keep her safe at home.
How would you distinguish this case from Raya?
I think the relevant facts here are that we have a parent who has demonstrated pretty serious parental failings that led to physical and emotional harm of the child, led to her being suicidal. While the child's refusal to engage, or lack of interest in engaging with mother, certainly impacted the department's provision of services, it was not dispositive here. And I think what is particularly relevant in this case is looking at the child's position on those things from when she was taken into custody through the time of trial, because one of the most important changes that happened was child started saying, I want no visits, I will not do family therapy with mother. And then the testimony was that the department discussed visits with her when she was refusing. Her clinicians were working with her on trying to get her to a place where she could work on that relationship for mother. And the testimony by the time of trial was that the child was now open to family therapy, was in a place where she could do that, which then provides some context for the judge's order that DCF shall engage in family therapy. Not because DCF should have physically forced her to sit in the room with a therapist when she wasn't ready, but rather in acknowledgement that at the time of trial, the child had reached a point, because of the services that were provided, where she was willing to engage productively in that therapy, that it should obviously happen immediately. That's something that was very necessary to work towards reunification. Do it now. But that wasn't an indictment on the department's services. It was a recognition that the child's position had changed on that matter, that the work that was being put in towards the relationship between mother and child appeared to be at least potentially bearing some fruit.
Had the department sought termination?
No, I don't believe we did. And Your Honor, you had asked what a good on-point case is, and I think the most relevant language can be found in Walt, and it's quoted again in Rashida, which is that under no circumstances should a child be left in an unsafe environment, regardless of whether the department made reasonable efforts to promote reunification. By no means am I conceding that we did not. The department did make efforts, and we see the results of those efforts in the change in the child's position. The purpose of the efforts to promote reunification is to address parental deficiencies. If at the time of trial, those parental deficiencies exist. If the judge's findings, as Judge King found, is that the child would be exposed to the same physical abuse, the same emotional abuse, because the mother had demonstrated no improved ability to parent, no improved ability to prevent herself from doing that, then the child can't go home. And that's the point of permanent custody. That's the reason why review and redetermination proceedings are available to parents. If she does develop those skills, she could seek review and redetermination. If the department continues to not provide family therapy or what services that are necessary, she has access to abuse of discretion motions. She has access to motions under Rashida.
And there was not an abuse of discretion motion filed before, during the pendency of the CMP?
No, there was not, which is its own reason why that argument is also not grounds for reversal.
And the child's with a kinship placement?
Yes. So she's in a position where she was doing well at the time of trial, could stay, and could reap the benefits of a stable, safe environment. And if mother improves her parenting such that the child could be safe in her care, her rights have not been terminated. That can be addressed down the road. If the department does not provide a service that is appropriate at the time it's appropriate, she has the ability to address that as well. There is no grounds to reverse the court's decision in this case. And if there are no further questions, I will rest on my brief.
I don't see any. Thank you.
Thank you.
Morning Honors, Michelle Mosherit, for the appellate child. Chief Justice, congratulations. May it please the court. I'm here to ask this court to affirm the lower court's decision granting the department permanent custody of my client and the finding of unfitness. I want to spend some time on a couple of issues. To your point, Chief Justice, the difference between Rhea and this case, Rhea, mother, complied with all the action plan, every single task. This case, mother didn't. So while there is a lot of pointing of fingers, while I also agree that the department failed to do its job, so did the mother. The mother did not comply with the DCF action plan. She testified that last time she met with the social worker was November 2022, and that's at least 4 months, I believe, prior to trial. Mother did not make herself available. Mother did not participate in individual therapy. Mother called the child demeaning names. Mother and her partner physically abused the child in a fit of anger. Mother, at the time of the trial, 16 months after the child was removed, still didn't have suitable housing for the child. Mother testified that she didn't have pediatrician available to the child if the child was to return to her custody. And as in terms of school, mother did say and testify that there's a vocational school in North Adams. However, she didn't have all the particulars. This child has an IEP. This child suffered while she was in the custody of her mother. This child, at some point, preferred to end her life than to return to her mother's custody. So I do agree again that the child made it clear from day one she didn't want to live with her mother. At the end of the trial, she didn't waver. Her position was still clear. Yet, she attended therapy, continues to attend therapy. She also made it clear she didn't want to see her mother after the first visit and the second visit. For 16 months, she only saw her mother physically in supervised setting twice. The third visit
That was primarily, though, by her choice, right?
By my client's choice. However, the issue here, and unlike what the mother just argued that the substance abuse was not an issue, which it was not an issue, was never an issue, and it did not cause the mother to lose the custody of the child at the 72-hour hearing. It was the relationship between the mother and the child that caused the removal. It was the relationship between the mother and child that caused the child to be in very dark place. Yet at trial, and the reason why the judge made it clear that substance abuse and mental health did not cause the child's removal, but rather lack of trust, the relationship between the child and the mother. And I believe the judge did so because he went to explain that the mother focused on other issues rather than the relationship between her and her daughter. Mother argues that DCF failed to do its job. DCF did fail to do its job by increasing visits, by not sending the parties to family therapy. However, DCF's failure to do its job did not render this mother unfit. At the time of the trial, mother was not ready to get the custody of this child. If there is no question, I rest on my brief.
I don't see any. Thank you very much.
Thank you.
The difficult cases, it is under advisement. Thank you all, counsel. Our next case is John Doe number 527402 versus the Sex Offender Registry Board, docket number 23P839. Good morning, Mr. Burkholder.
Good morning, Your Honors. Congratulations.
Thank you.
May I proceed?
Absolutely.
May it please the Court, Attorney Fred Burkholder for John Doe, 527402. So, everybody's read our briefs. I know Roxanne did a great job. I think that my brief outlines...
Could you just turn the microphone a little bit towards your...
I think my brief outlines all of the issues, but doesn't give adequate attention to the issue of attempt.
Of what?
The issue of attempt. I don't want to say that I agree that Doe 36870 controls all the issues with regards to the actual index offense of sexual contact with a minor versus assault and battery, for the following reason. The Arizona statute criminalizes consensual sex between a defendant and a 17-year-old boy, which is not prohibited by any Massachusetts statute. This is in my brief. And the Massachusetts statute criminalizes non-sexual indecent touching of a 13-year-old boy, which is not prohibited by that Arizona statute. Now, I'm cognizant of the fact that in 3680870, the court kind of gives us an outline of what's required. And they state, while this is different from the required proof in Massachusetts, we consider the like violation requirement satisfied when it shows that the proof necessary for the out-of-state conviction would also warrant a conviction in Massachusetts, which requires registration. So we have some question whether or not they cover the same things. It gets even more problematic when you start looking about the issue of intent. Counsel at the 30A level raised the argument. I didn't embellish it as much as I wish I should have, but I did highlight it, so I'm going to try to expand on it. Basically, we have two different approaches, as I understand it. One is we have a proximity approach, which is what Massachusetts has, and the other is we have a model code approach. Now, you say to yourself, why do we care? Well, why we care is the following. If you look at the Arizona statute with regards to attempt, it says, a person commits attempt if acting with the kind of culpability otherwise required for commission of an offense, such person intentionally engages in conduct which would constitute an offense if the attendant circumstances were as such person believes them to be. I don't know what that means.
I don't either, but what about the second part?
Okay. Intentionally does not or omits to do anything which, under the circumstances as such person believes them to be, is in any step in the course of conduct planned, is in any step in the course of conduct planned to culminate in a commission. What that means is you can be in wherever, but if you have the requisite mental culpability, so. Massachusetts says, not so much. You got to be close. And what do they mean by close? Boswell, which is the leading case, which is 486 Mass 92, says, when an individual prepares to commit a crime but has not undertaken the last act necessary to accomplish it, the preparation will qualify as an attempt only if it comes very near to the accomplishment of the crime that the intent contemplates to and renders it the crime. So where am I going with this? Notice and clarity. If you're in Massachusetts or if you're in Arizona and you're looking at potentially this statute and you say to yourself, well, I'm over here and I'm thinking about doing this and I did one step but I'm not anywhere near finishing it, am I put on proper notice that my conduct might require me to register? I've wrestled with this concept in my brain, which is getting older and doesn't function as well as it used to, but I came to the following conclusion. You could do the Arizona, you could satisfy the Arizona elements and still not satisfy the Massachusetts elements because you don't have the proximity.
But you're getting the proximity element from a case, right? I don't see it in the statute.
It's actually in the jury instructions, Your Honor.
Okay, but the statute, if you compare the statute, Massachusetts statute defining attempt with the Arizona statute, the second part, they're very similar. How do we know there's not an Arizona case out there that says the same thing as what you just said?
Well, because the Arizona case that deals with it is cited in the motion for judgment on the pleadings, and it is, well, let me go backwards by saying it this way. The case of State v. Mott, which is cited by trial counsel, 30A counsel, deals with the fact that Arizona is a model penal code state. And that case dealt with whether or not you could raise an insanity defense, and it said that you could not. I'm not stating it properly, but in essence, you were limited with regards to what a model penal code would allow you to do and what was permissible there. Versus what the jury instructions for an attempt here say, which is the following. Under subsection 4, they deal specifically in bold print, proximity to success. And they cite the following. When further acts on the part of the person who has taken the first steps are necessary before the substantive crime can come to pass, such first steps cannot be described as an attempt. An overt act is not punishable if further acts are contemplated as needful. But some preparation may amount to attempt is a question of degree. If the preparation comes very near to the accomplishment of the act, the intent to complete it requires the crime so probable that the act will be a criminal attempt. Certain factors must be considered, determining whether acts constitute mere preparation or are enough to establish the crime attempt. These factors include the gravity of the crime, the uncertainty of the result, and the seriousness of the harm that is likely to result. So my argument in essence is it's a lot more particular with regards to what is required here and what the statute in Arizona allows and requires for a conviction may not necessarily require a conviction here. And because of that, I don't think we have a like offense, because the whole purpose is notice and clarity.
What do you make of Attorney Greenaway's argument, I think it's at page 38 of her brief, that the Arizona statute is a like offense to our rape and abuse of a child statute?
I was waiting for you to say that, because I just got slammed on that argument 4 months ago by this very court. And what was done in that case was the following. That case, I made an argument, or the argument was made that there was an alternative. It was raised at the Superior Court level just as it was raised in this case. I made the argument that it's beyond the court's authority to rely upon something that the board didn't do. The appeals court wasn't so enthused. They said my argument was trivial. Now, I'm going to tell you, I'd like you to talk to some of the people that are out there on the streets that have classifications, and you tell them that it's trivial.
Your arguments are never trivial. What I'm trying to understand is...
That's what they said.
Well, with the three of us on that panel, I'm guessing not.
I don't think so. But I've been waiting for that argument.
But I guess the question is, you know, you may not have been here this morning. We had a case where we talked about, can you affirm on any anything that's apparent in the record. And so if we were to conclude, and I'm not speaking for the panel at all, but I'm hypothesizing that the statute that the board used wasn't a like offense, but we do have a like offense, could we affirm on that basis?
Well, I mean, it gets down to the issue of notice and clarity, and it gets down to restriction with regards to what the rights of the court are.
So then is it potentially a remand for the board to
Yeah,
reconsider
and
it?
that's where the last panel got hung up.
Is that
They-
a published decision, the last one?
Well, let me give you, the docket, no, wasn't published. The docket, it was, where is it? Where is it? See, I told you I'm getting old. Can't always find everything that I want to find. 22P 1062 was the decision, I think it was 4 months ago.
Okay, thank you.
Now, I just want to read you something, and then I'll stop talking. It says, with regards to that, let me see. First is the board, 98 Mass Appellate Court 307, which is DO 58574. The board alternatively contends that the examiner properly denied Doe's motion, and this had to do with funds for an expert. They go on to say, while we can conduct a meaningful of a decision of less than ideal clarity if the agency's path may be reasonably discerned, we will not supply a reasoned basis for the agency's action the agency itself has not given. Cites Costello versus Department of Public Utilities. Also cites Doe number 11204, which is at 97 Mass Appellate Court 564. Remanding, in that decision, remanded for examiner to consider board's alternative argument for affirmance made at the first time on appeal. In bold print, the basic rule is clear: an agency must defend its action based on the reasons it gave when it acted. So can you do it? Sure you can do it. Is it going to get sent back and that argument's going to be made again? Then I'm going to stand on my attempt argument. But the reality is if we're going to play whack-a-mole every time and say, okay, well, there's another offense, there's always another offense.
When's he up for reclassification?
I don't know that. You would have to ask me that question. Let's see. Decision was issued on March 22, so he's up, yeah.
So he's up
3
this
months.
spring.
3 months, yeah. But I don't want to hear that argument.
I'm
I
just
hear that
asking.
argument, with all due respect, Your Honors, it's like, we wait until we get this far, and then if the case gets kicked for reclassification, then this
Well, but the
craziness
remand,
continues.
the remand could impact his reclassification hearing, which is why I ask if
Well,
there was a remand.
It certainly could. What my bigger problem is I stand up here and I fight for these guys, and then because they get so close to reclassification, it gets sent back, and they do it all over again.
Mm-hmm.
They do, knowing that it's going to take me 3 years to get somebody to listen to me, and then sometimes I get the decision like I got from another panel 4 months ago, which frankly I was quite surprised at. I thought, how could he say it's trivial? I mean, send it back, let the agency do their job, that's what their job is. I have nothing further if there's any questions.
I don't see any. Thank you, Attorney Burkholder. Attorney Greenaway?
Thanks for your help. Hang on, I gotta get done cleaning house here. It takes me forever, I'm old.
Good morning, Justices. Roxanne Greenaway for the board. I think in my brief, I mainly bring up the attempted rape and abuse of a child to point out that indecent assault and battery is a lesser included of that offense. And so if you have enough for the lesser included, you certainly have enough. So with regards to the attempt statutes, you can look at them. The language is not the same, but it's quite similar. In the Arizona statute, you have them indicating that it's any step in the course of conduct planned to culminate in commission of the offense. And Massachusetts has any act toward its commission. So we're using different words to say the same thing.
How far beyond the words of the statute do we go to determine if something's a like violation?
I'm sorry?
How far beyond the actual words of the statute do we go to determine whether something's a like violation?
Well, I think the law says that we are supposed to do the elemental approach.
Right, so I'm not saying we look at the facts, but I'm saying, so your opponent relies on jury instructions. Like, how far do we go into cases interpreting the statute or jury instructions to determine if something's a like violation?
Well, I think we stick to here, in this case, we have the Arizona statute, so that's what's in the record, so that's where that's what was before the hearing examiner, and there is nothing further before the hearing examiner
Just
or
the statute.
or the court to indicate that there's any other definition. I think when it comes to statutes, we look at the common sense meaning of the words in the statutes. Certainly in Massachusetts, we do have case law, and we do have the jury instructions that lays out the elements of the offense, which is why I included it in my brief as well, just to show that what is required to be shown as the elements of the offense in Massachusetts is sufficient for what occurred in Arizona. And what we have in Arizona, I know my brother speaks about attempt, but when you look at the crime that they're attempting, it may be quite different, right? And what we have here is an attempted rape of a child, or an attempted sexual assault or oral sexual contact with the private parts of the child. And when you look at what occurred, he pled guilty to it. So you have a situation where he went very close to the commission of that offense. And the hearing examiner found, as a subsidiary fact, that the penetration did occur from the child's description of how it stung and how it hurt and the words that were used in the commission of that offense. So while we originally have the elemental approach, and I would argue that when you look at those between the Arizona statute and the Massachusetts statute, that you certainly have enough to satisfy a like offense.
We can't consider the hearing examiner's findings that there was penetration.
No, not in the elemental approach, no.
Okay.
And I think that the main argument was the like offense. As far as the likelihood of success on the merits with regards to the hearing examiner's finding that there was a clear and convincing evidence that the board has met its burden, certainly you could look at the two statutory high-risk factors that were applied with increased weight. And with all of the factors, I would invite the court to look at the record, and I tried to include in my brief where in the record the hearing examiner would rely upon such findings, so that you see that every factor that was applied by the hearing examiner has substance in the administrative record that was before the hearing examiner at that time. So there is nothing showing that there's any error in the application of those factors. And then you would have to take into account as well the additional sexual misconduct that the hearing examiner found in addition to the index sex offense. So you do have that he did sexually assault a 13-year-old girl additionally, as well as while he was on probation for his index sex offense, his probation officer found child sexual abuse material on his telephone, gave that to the police who did a forensic search and found even more. So again, in the record, there is substance to support the hearing examiner's subsidiary findings in that regard. So I would ask that the court would uphold the hearing examiner's decision and find that he currently presents as a level 3 sex offender, if there's no more questions.
I don't see any. We'll take the arguments on the brief. Counsel, thank you very much. Excellent arguments and briefs. Appreciate your cooperation. It's nice to see. And the matter is under advisement.
And congratulations, Chief Justice Blake.
Thank you very much. And our final case of the morning is, the afternoon, Joel Austin Lord versus Marsha Berger, docket number 23P1472. Good morning.
Good afternoon, Justices. Mark O'Brien, representing the appellant, Marsha Berger. May it please the Court, I'd like to begin with the Webster Dictionary, which touches on what contempt is as far as the English language. It's lack of respect or reverence for something. And then they go down to number 3, willful disobedience or open disregard of a court, judge, or legislative body. And I think that with regard to this case, I think the judge made a mistake. I don't think that Defendant Berger, for two reasons, I don't think she was in contempt because the first prong had to do with the question of $50,000.
Could I ask you one question before you go too much
Certainly.
further? My understanding is that you are appealing from the motion for reconsideration, although I read your brief to include a challenge to the contempt. What is it that you're appealing?
Well, in that, the motion was the reconsideration asked the court to reconsider its decision on contempt. So I think that contempt is included therein, if you will. But I also wanted to add to that, because I know that my brother has pointed out that certain things weren't pled in the appellate brief. However, it's my understanding that this court is not thereby constrained, that as long as something appears in the lower court record, that it's within your purview to examine it, sua sponte, you might say.
So
And
you're appealing both the contempt finding and the denial of the motion to reconsider?
Right, because the denial of the motion to reconsider was addressed to the contempt issue. It perhaps was pled wrong, but I think you understand the meaning of
Well,
the...
except that we have specific rules, right, that govern this. So say in the criminal context, someone was convicted for shoplifting, and then they didn't file a notice of appeal of that conviction, but then they filed a motion for a new trial, and that was denied, and they filed a notice of appeal of the motion for new trial. We would only consider the merits of the motion for new trial because they hadn't filed a notice of appeal of the underlying shoplifting conviction. And when I look at your notice of appeal, which is at the supplemental appendix at 88, you say that you are giving notice of your appeal of the September 22nd, 2021 order denying the motion for reconsideration, the order regarding the payment of legal fees to plaintiff's counsel, and the order to pay 80% of the special master fee. What's not included in the notice of appeal is the adjudication of contempt.
Well, I don't know what is within your powers to do, but I would like that to be reviewed because it certainly came up in the lower court record, so I think you would have the authority.
There's no question it's there, but the question is we look through a very narrow lens, and particularly in a civil case, it's what the litigants have appealed. And I think fundamentally the first question we all have is, did you appeal, is there a notice of appeal from the finding of contempt? I don't see it. If it's in the record, I would love for you to point it out to me.
I don't think it's in the record, and I think that my brother pointed that out, but it should be because that's what we would like to appeal. Both, the denial of the motion to reconsider and then the initial contempt finding.
All right, so let's say that the original contempt finding is before us and we're reviewing it. What's your argument that the original finding was an error? It seems like you're trying to rely on affidavits that were attached to your motion to reconsider. But at the time the original finding was made, what's the defense to contempt at that point?
There's two situations that arise in my way of looking at things. The order was to pay $50,000. She had paid $25,000. If you look at the Smith case, Smith versus Smith, when the litigants agree and then they pay less and it finally gets to the court has said that that's okay. That's not that's not contempt. However,
he had previously agreed to accept $25,000, but then he files the complaint for contempt, which
well, see, that's what's confusing about this case because apparently the litigants were negotiating amicably, so I don't think it was so much the litigant that contested the missing $25,000. I think it was the litigant's lawyer. However, if we could skip forward, if that problem is cured on the day of the contempt hearing, it's considered moot. That's my understanding of the rule, and it's in the appellee's brief that the case that I cite is in there. If everything's settled the day of the hearing, and the total $50,000 is paid, which it was, I believe that issue is considered moot.
The money was paid before the hearing took place, the total 50?
You know, that's not really clear, but she had her checkbook with her, and they had a discussion before the hearing, and she had agreed that she would pay the
There
missing
was still
20.
discussion that took place at the hearing about the outstanding 25, correct?
Before the hearing, it was to
But on the transcript, isn't there discussion in the hearing transcript about it, a $25,000 shortfall?
the $25,000 shortfall is noted by the judge in her order, but it had already been resolved. That's why I'm confused about the order. Now, the second prong, if you're ready for that, is what are the extraordinary circumstances? I think in this case, the extraordinary circumstances regarding a motion to reconsider is that all these issues that are raised on appeal and objected to by my brother, they were raised. They were raised by Attorney Solomon, and he got to court and he wanted to have his motion for reconsideration heard. It was within a year after the finding of contempt, and the judge said, and I'll paraphrase, she said, that issue has already been decided, but that's not what a motion for reconsideration is about.
Can I ask a question? Are you talking about the motion for relief that you discuss in the brief, or are you talking about the motion for
relief was kind of kooky because that was written pro se and it was titled wrong, and it was, I don't know, apparently it was written, it was filed by my client, but never got into the docket.
Okay, so it was, okay.
But that was the first volley, if you will. The second one, Attorney Solomon wrote and filed a motion to reconsider, and the court told him, well, that's already been decided, which is not the proper answer to a motion to reconsider, I wouldn't think.
And did you file a motion to reconsider, or was that Attorney Solomon's motion that we're talking about here on appeal?
Well, my client's motions, as I said, were kooky, and I don't know what, but nonetheless, she does, you know, if you want to talk about due process, she did come up with some very valid points, but she titled them wrong and filed them wrong, and they weren't docketed and so forth.
But there's an unsigned motion to reconsider under your address, starting at 155 of the appendix. It's a motion opposing plaintiff's motion for legal fees and motion for reconsideration of contempt order. Our copy is unsigned, but it's under Mark Ellis O'Brien in Lunenburg.
I think that was signed electronically when it was submitted to the court.
So was that filed and heard?
Yeah, yes, it was heard. This was toward the end of the whole proceeding.
And is that what you're appealing from?
Well, they're appealing the denial of that. There's no real way to appeal Mr. Solomon's motion because it wasn't even heard or reviewed.
So let me ask you this. The motion that is under your signature, the one that Chief Justice Blake was just referring to, argues for reconsideration under 60B1 and 60B6. So 60B1, what is the ground that you were relying on for the mistake, excusable neglect?
I'll retract that because, as my brother pointed out, 60B1 doesn't apply, but 60B6 does because there's only the time constraint is reasonable time.
Right, but I'm asking this because I can't quite sort out in my own mind what the arguments are. Because if you have an argument under 60B1 and it's untimely, that doesn't permit you to then bring a 60B6 claim for the same argument. If you understand me, you can't get around the 1-year time limit on that. So I'd like to know what the 60B1 argument is, and is it different than the 60B6 argument?
It's different, but the 60B1, I believe, was going to be argued that there was new evidence. However, that's out because of the time frame. So this was a tough case for me because my client wanted to get the contempt citation off her record, and if she could, she'd like the return of the resulting legal fees. However, I said, Mrs. Berger rather, I said, there's no way that I can see that this can be done.
Just be sure you're not sharing with us anything that's a client.
No, I'm not. But the point is, there was no way out of this. When I came into this case, it was a train wreck. There was no way to get that citation of contempt removed that I could envision except the motion to reconsider, which failed, and then appeal that. But in answer to your question, 60B1 doesn't apply because no matter what was argued, the time frame knocks that one out. but I think 60B6 does apply.
But so are you conceding for our purposes that that 60B6 is not on the table? Are you agreeing that that
60B6
doesn't?
is, but 60B1.
I'm sorry, 60B1.
Yeah, just the way you said it first, 60B1 does not apply.
Okay.
So I'll concede that.
So I'm sorry that I interrupted you. The basis for the 60B6 motion is what?
Extraordinary circumstances. For instance, all these issues were raised, and they were raised well in poorly filed, poorly written motions by the pro se litigant. But on the other hand, Mr. Solomon's motion was well-written, was docketed, and when he got to court, the judge said that's already been decided.
Where is that motion? I'm just not clear on where in the
Mr.
record
Solomon's
is that?
motion is, let me just look at the appendix for a minute.
Sure.
Mr. Solomon's motion is within a year after the,
It's at record 191, counsel.
I wouldn't know, but I have it in my appendix.
I found it. It's okay.
You did, all right, thank you. But that was Mr. Solomon's motion. So I think you want to talk about due process, that motion should have been heard. So I don't know how to.
And there's no appeal from that, from the lack of action on that.
Unfortunately, no, he didn't appeal that.
So I want to circle back to Justice Hand's question, which is, what is the basis of the 60B6 motion?
It's extraordinary circumstances.
And what are the extraordinary circumstances? Could you list them for me?
Yes, that all these issues were raised by the appellant, but never heard for one reason or another. That's extraordinary.
So is the failure to address Attorney Solomon's motion the basis for your request for extraordinary circumstance relief?
Both. That is certainly trumps the other one, but the other one is if a pro se litigant comes forward with things that she thinks should be heard and that it just for some reason doesn't get into the docket. And, you know, my brother pointed out, well, the docket should come to this court corrected. Well, the docket was correct in the sense that the things never were docketed that she sent in. So that was a correct reflection.
And are you talking specifically about the motion for relief?
Well, there were 3 motions that she wrote that, you know, they were well-meaning and they were well-argued, but they were poorly titled and so forth, and they never got to the docket.
And is there anything in the record to show us that they were properly filed? I understand that at least one of them, there's an indication that it was provided to, there's an affidavit about to whom it was provided.
I think that if you look through the record, she states that in her affidavit that she filed with my motion to reconsider, which was toward the end of this case. She stated all that, and then opposing counsel in one of his emails, which I believe is in the record, he conceded that when Mr. Solomon got to court, he was just told that that had already been decided, and we'll move along from there. But I think we would have to rely on her sworn affidavit that she did send these things in. And she goes into the detail, the clerk it was sent to, and I think she had a subsequent conversation with him by email. But the more important...
Do you have a date-stamped copy showing she filed it? Is there anything like that in the record?
Because I believe in her pro se status, I think that the procedure was to send it by email. But I think if you look in the record...
Does she have an e-file receipt?
I think so. I could get that for you. I'm not sure if it's in the record, but I know that she does have certified mail copies that were sent to the court that she did to prove that she sent these things.
And is the certified mail, is the green card in the record? Because I didn't see it.
I didn't see it either, but I could get it for you if it would be helpful. It does exist.
Let me just check, because we are out of time. I want to make sure my colleagues are all set. Okay, we'll have to leave it at that. Thank you very much. Attorney Johnson.
Good morning, Your Honors. May it please the Court, and
Can you pull the mic down?
Yes, I can. And congratulations, Chief Justice. I would just like to take a moment to address a couple of things that my brother said. The funds that he referenced were not paid prior to the hearing. They were actually paid after. The court ordered Ms. Berger to pay those funds at the end of the hearing, and that's in the record, the record appendix at 137, 138.
Actually, before you get into the substance of your argument, can you tell us what you think is on appeal?
So I believe what's on appeal is the motion for reconsideration, which would be considered under an abuse of discretion standard, which I don't believe is met here.
Well, let me ask you this. The finding of contempt is on an order, not a judgment. And so if there had been a notice of appeal filed from that, wouldn't that have been interlocutory?
Yes, it would.
So has there ever actually been a judgment of contempt in this case?
So I would say that the judge in the judgment of September 21st, or September 22nd of 2021 does reference the finding of contempt
So
in his
he's
findings.
incorporated the order into the judgment.
In his findings, he does reference that there was a finding of contempt by a prior judge, Judge Burchell, and that is incorporated into his judgment and into his decision to deny the motion for reconsideration.
So then why isn't the notice of appeal of the September 22nd, 2021 judgment inclusive of the finding of contempt?
Because there's still an obligation to notify the court as well as the appellee what is being appealed. And here he doesn't do that. He strictly limits his appeal to that order on the motion for reconsideration as well as the legal fees and the judgment incorporating the special master's division of the fee payment to the special master 80/20.
But that's not that's in the rules, but it's not a jurisdictional requirement. So if your client wasn't prejudiced, then why shouldn't we consider everything that's encompassed within the judgment itself?
So even if you do consider it, I think that it's still an abuse of discretion standard that would have to be reviewed. And the judge would have to say that there was some whimsical thinking, some arbitrary decision in finding her in contempt. And even if we get to that, there is nothing here in the record, nor in any of the arguments that have been made that shows that there was any arbitrary or whimsical thinking here to overturn a finding of contempt. There were 3 judges assigned to this case, 3 judges, and whether or not certain motions made it onto the docket or not, there were 3 judges that made a determination and ultimately ended the case with a judgment finding her in contempt. And she admits on the record, in her answer, that she didn't pay certain funds, and she also admits or doesn't deny that she didn't sign transfer documents to transfer the document or transfer the business over to Mr. Lord. And by doing so, she's admitting to being in contempt. So even if we get to the issue of whether or not the judgment incorporates that and there wasn't an initial finding of contempt, or I'm sorry, if there was a finding of contempt that's incorporated into that judgment, it's not an abuse of discretion here, and I don't think it should be overturned. And I just want to point out a couple of other things that my brother had mentioned is these motions that haven't been acted on, which are the circumstances in which he believes that under Rule 60B-6, his motion for reconsideration should not have been denied. And I first want to direct the court's attention to Commonwealth versus Du Bois. It's 451 Mass 20. It's a 2008 case which talks about when a judge fails to rule on a motion at the trial level, that when it goes to judgment, that those are an implicit denial. So even if there's not a formal denial of a motion, that can be an implicit denial based on the fact that it wasn't acted upon and the case went to judgment.
So Solomon's motion was received and docketed, right?
It was.
What about Ms. Berger's pro se pleadings?
There's nothing in the record to indicate that it made it to the docket. And
Have you seen an e-file receipt, a green card, anything?
I believe at one point, my brother sent us a copy of a receipt from her sending some documents, but it wasn't a certified mail receipt or return receipt requested. It was just a receipt from the post office, which...
Saying something had been mailed.
Exactly, and I don't know what that was, and I often do not recall what the time frame or the date of that receipt was at this point.
What is your response to Mr. O'Brien's argument that the basis for the 60B6 motion is the failure to act, I guess you just answered that on Mr. Solomon's motion, and then this attempted filing by Ms. Berger?
So what I would say to the 60B6 motion and the failure to act on certain motions is first the implicit denial. Second is there's case law, and I believe it's Mahoney versus Mahoney, 65 Mass App, Court 537, that states that not all complaints for contempt require hearings or evidentiary hearings or even live testimony, that the judge can, if there is no material fact that's in dispute, which I submit that there's not. She's admitted that there is a lack of payment made, and that she didn't believe that she needed to transfer the business through a formal transfer document. She admits to these facts, and the record reflects that. So I would submit that there is no material mistake or material fact in dispute, and thus she's not entitled to a hearing. I would also turn your attention to the supplemental probate and family court rules 2-99. I believe it's B1, which states that a judge may hear a motion for reconsideration or relief under Rule 60B6 if they deem a hearing is necessary. At the time of the final hearing in September of 21, the motion was then filed after, and the judge had explicitly stated on the record, and I don't have that cite with me, but had explicitly stated on the record that he would, if he felt necessary, have a further hearing on the issue of attorney's fees. At that time, my understanding from the record is that the only issue at that point was legal fees. And my brother then submitted a motion for reconsideration of the underlying contempt action as well, which the judge did give leave for him to file in opposition to our motion for legal fees, which had been pending for several months. At that point, I believe it was in May of 21 that motion was filed. But he did rule on that motion very specifically and included that in his judgment. Unless there are any other questions, I would rest on my brief.
I don't see any. Thank you very much.
Thank you, Your Honors.
This matter is now under advisement, and that concludes our sitting today. I would like to thank the court staff, especially our court officers and our law clerks and the wonderful timekeeper. So we will now stand in recess. Thank you all.